Straight ahead on Law&Crime Daily. 27 years later, the case that shocked the nation.
All of the evidence points to O.J. Simpson.
But not everyone's convinced the juice killed his ex-wife and her friend.
Just believe in my heart of hearts that Simpson absolutely 100% was not guilty.
And closing arguments in the Tennessee trial of a father accused of murdering his 5-year-old son. Will a jury believe his confession was coerced? Plus, accused murderer and real estate heir Robert Durst hospitalized during his trial.
We cannot proceed without him being here.
Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmire along with Terri Austin. 27 years ago this weekend, tragedy struck, leading to one of the most sensational criminal trials the world has ever seen. Angenette Levy has more on the O.J. Simpson case.
Brian, this case set off an absolute frenzy. To this day, there are people who support O.J. Simpson's claims that he is innocent. One of his former lawyers is one of them. But there are others who say that O.J. Simpson is a murderer.
June 12, 1994, Nicole Brown Simpson and Ron Goldman were found in a bloody crime scene in front of her condo. After a 9-month trial, a jury found O.J. Simpson not guilty.
It is clear that O.J. Simpson, in my mind, got away with murder, and that he was eventually held to account to some degree in the civil trial that occurred months later in Santa Monica.
Law&Crime Network founder Dan Abrams covered the O.J. Simpson trial.
The defense did a very good job of sort of creating all these possible theories. Mark Fuhrman planted the glove and planted the evidence.
One member of the Simpson defense team who stood by O.J. Simpson's claims of innocence literally to his dying day was F. Lee Bailey.
The first thing you have to show is opportunity. If the defendant had no opportunity to commit the crime, case over right then. In the Simpson case, there was no opportunity.
Bailey wrote about his part in the case and his steadfast belief in Simpson's innocence in The Truth About the O.J. Simpson Trial by the architect of the defense. Jenny Sisson helped Bailey write the book.
What's startling is the lack of blood evidence that was linked to OJ. I mean, really, it was such a bloody scene. How could there be so little blood at his residence and other places?
Questioning blood evidence was the central part of the defense. The blood in Simpson's Ford Bronco, the blood at the crime scene, and the bloody glove. The defense suggested Detective Mark Fuhrman planted the bloody glove on Simpson's property, while the state argued it wasn't planted and that Simpson owned the shoes that left footprints at the crime scene. Pat McKenna was one of Simpson's investigators.
It really was a travesty. It exposed LAPD and there was plenty of good cops, trust me. I know I met some good people. They weren't all bad, but there was a few people in there that said it's win at all costs.
The families of Nicole Brown Simpson and Ron Goldman were devastated by the jury's verdict in the criminal case. Months later, they received some measure of justice when a civil jury found Simpson responsible for their murders.
The picture of O.J. Simpson wearing the Bruno Magli shoes from a newsletter from 9 months before the murder is the final piece that should convince anyone who had any questions about O.J. Simpson's guilt.
The jury in the civil case awarded the families of Ron Goldman and Nicole Brown Simpson $33.5 million, but O.J. Simpson has never paid that judgment. Ron Goldman actually obtained the rights to a book that O.J. Simpson wrote back in 2006 called If I Did It, and he then published that book and collected the proceeds from it. Many believe that book was essentially Simpson's confession. Brian?
Thanks, Angenette. Joining us today is a judge of the Texas 292nd District, the Honorable Judge Brandon Birmingham and Terri Austin. Your Honor, skilled attorneys representing a guilty man, an innocent man vindicated, or something different altogether. Where do you think the case of O.J. Simpson lies?
I think it's the best example we have in our jurisprudence between somebody who is innocent versus somebody who is. I think that the jurors were not convinced that he was guilty, but I agree with Mr. Abrams and a whole lot of other folks that OJ got away with murder that day. But it just wasn't proven beyond a reasonable doubt. The defense did a good job of poking holes in that case, and that's the verdict.
Yeah, I always tell people there's never a box on a verdict sign that says innocent. It's either guilty or not guilty. So it's very hard to prove innocence there. So I agree with you there. Terri, you've had a belief since the verdict of O.J. Simpson. Has anything from O.J.'s lawyers made you think differently?
Not at all, Brian. And this is such a partisan issue. I think people either believe he's guilty or he's not guilty, and any evidence to the contrary doesn't really change anyone's mind. I think it was overwhelming. I think he had a motive, he had an opportunity, and I think he had the means, and there were no other viable suspects. And the thing that really, in my opinion, makes him guilty is the chase. I think that that is absolutely something that makes it seem as though he has consciousness of guilt. And he also, threatened suicide. It's just no question in my mind that there was enough to prove him guilty. But obviously, the jury did not think the same way.
Yeah, but as Dan Abrams says, those shoes and even the book after the fact kind of leads you to believe he probably did it. But again, he was voted not guilty. Angenette, the Simpson case led to some changes within the LAPD, right?
Yeah, major changes, Brian. There were changes made to the crime lab and how they collected evidence. The feds actually came in at one point. That was after, of course, the Rodney King case, and did an overhaul of sorts. There were changes made to several protocols, and the DA's office actually made changes as well to the way they would try these cases, the way they presented things to the grand jury. So there were sweeping changes that were made, huge lessons learned, especially with the collection of evidence and the protocols for storing that evidence.
Absolutely makes sense. You've got to prosecute a little bit better if you don't want things like this, O.J. Simpson getting off his murder, as many people believe. Still ahead on Law and Crime Daily, Robert Durst's first trial may be on pause while he's in the hospital, but that won't stop attorneys from arguing about the so-called jinx. But first, the trial of the Tennessee father who confessed to murdering his 5-year-old son, then recanted. Closing arguments next. Welcome back. A jury is now deliberating the fate of a Tennessee man accused of killing his 5-year-old autistic son. Joseph Ray Daniels is on trial for allegations he murdered Joseph Clyde Daniels, also known as Baby Joe. The boy is last seen on April 3, 2018, and reported missing the next day. His body has never been found. The prosecution called roughly half of the 60 witnesses they expected to call. The defense called none. Alex, the defendant's now 11-year-old stepson, took center stage in closing arguments. The prosecution pled with the jury to believe the boy, who was just 8 years old when his little brother was murdered.
You saw Alex testify. He was 8 years old when this happened. And he said, I didn't tell the truth in the beginning because I was trying to protect him. But that was a lie. He said, I'm here to tell you the truth now. I'm here to tell you what happened. And here's what the defendant says about Alex.
Alex, yeah, he's a good boy. He doesn't lie. He tells the truth. It's always admirable. We talk not to, not to lie to anybody, tell the truth. And I know they interviewed Alex and made sure you told him everything.
The defendant says, Alex is a good boy. He doesn't lie. I know they interviewed him. I'm pretty sure he told him everything.
The defense, in turn, wanted to present a different argument. They now claim that the then 8-year-old stepson caused Baby Joe's death.
Is whatever Alex told them. Agent Boyd is threatening to investigate Alex. The next page, page 135. Agent Boyd, I understand that what I I want you. I wish you would believe me when I told you that no matter what you tell me right now, you tell me the truth, you'll walk out that door. You're walking out of here, okay? I promise. I can promise you that no matter what you say right now, you're walking out that door. He's asking him to say Alex did it.
Back with us is Judge Birmingham and co-host Terri Austin. Terri, what do you make of the prosecution building their case on the words of a now 11-year-old stepbrother? Was that testimony powerful?
Oh, Brian, it was very powerful. There's no question that Alex loved his little brother, and I think there was even some survivor's guilt there. And, you know, the prosecution relied on that testimony, and they also relied on the testimony of the speech therapist. The therapist was amazing. She said that Joe Clyde was a loving little boy. He loved his apples. And the prosecution relied on that. The prosecution actually opened up with that and closed with that, talking about the fact that this little boy had a simple little desire to have apples. And the last thing that the prosecution said in closing was, I won't ever see an apple again without thinking about baby Joe Clyde. And frankly, Brian, I won't ever look at an apple the same either.
Definitely powerful arguments to leave the jury with as they go into deliberating. Judge Birmingham, the defense, out of nowhere, is kind of leaving this little nugget that the then 8-year-old stepbrother maybe did this crime in some way, shape, or form. What did you make of that? A great last-minute move or a misstep by the defense?
Well, certainly something inconsistent with the idea that he just totally made up a confession and that had nothing to do with the killing of baby Joe. If you're going to say that the 8-year-old brother was involved in somehow in opening the trunk and doing that, well, that implies that the baby was killed at the house. And then you've got to rectify that somehow with this confession you're saying is falsified. And when you put all of these different pieces together, it is a tough road to hoe for the defense in this case.
Absolutely. The jury is still continuing to deliberate, listening to all of the testimony. And if you recall, what do you think about this not putting on a defense, Terri? No witnesses or anything from the defense? What do you think of that?
Well, you know, it would have been hard to put on the defendant himself. I mean, I suppose they could have put on a psychologist, but I think at the end of the day, if I had been that defense, I probably wouldn't put anything on either.
Yeah, I would have guessed maybe a false confessions expert if that is what they were going with, talking about recanting and showing the elements of that to a jury, but that's just this public defender's from Brooklyn opinion. We'll see how this case goes out of Tennessee. Coming up on Law&Crime Daily, all is fair in love and drug cartels. Why one drug kingpin's wife is going to the big house. Plus, we ask the experts about the compelling testimony of an 11-year-old boy against his stepfather, accused of killing his son. More on the murder of Joseph Clyde Daniels next. We're back. Jurors are continuing to deliberate in the Tennessee trial of a father accused of killing his 5-year-old autistic son. Terri Austin spoke with a clinical psychologist who discussed one of the state's key witnesses.
Brian, Alex was just 8 years old when his brother went missing. He's 11 now and was emotional on the stand. Dr. Catherine Coleman says kids in general know the difference between the truth and a lie.
As adults, we're abstract. We can think about consequences, but kids are very much black and white, right and wrong. And so kids, by and large, understand the difference between lying and truth telling. And for them, lying is bad and telling the truth is a good thing.
I saw him laying on the ground.
Who was laying on the ground?
Joe.
Joe Clyde?
Yes.
And what was the defendant doing?
He was about to pick him up and carry him out the door. He said that he would tell me if I didn't help him.
So back at the time when he was 8, he didn't tell investigators anything, but now he's 11 and he is testifying that his stepfather beat his baby brother. What do you think about those inconsistencies?
So I think, at the time when he initially didn't provide any information about what he saw or didn't say anything that was incriminating about his stepfather, there was that threat of violence if he spoke out. And so that could influence and make him more suggestible in what he's telling investigators.
Did anyone get a butt whoop him? No. Did Daddy ever butt whoop anyone? Yeah. Yeah, who would he butt whoop?
Me, don't.
Could he be feeling some guilt because he was the one who actually informed the stepdad that his little brother had, urinated on the floor? And it did seem as though he felt a little guilt. That's when he started to get very emotional.
Yes, in any situation like this where there's some type of trauma, sometimes there is this survivor's guilt. Why them? Why not me? Was I the person that caused this? When he refers to his stepfather in the courtroom as that man and him, what that shows me, though, is that he's really distanced himself from the situation, and that he may have kind of a bigger grasp on the fact that that man, allegedly is bad. And so he's able to separate that that's a bad man that did a bad thing, and that I necessarily didn't do anything wrong.
Do you recall telling a different story?
No, I actually do. But it was fake. It was a false story.
How do you think the jury is going to respond to a child on the stand? He's only 11 years old, and he's doing a great job testifying. What is the jury thinking about?
Anybody, our hearts just always bleed for children. And so when you see a child providing testimony, especially when they become emotional, right, our emotional side is going to want to reach out to that kid. And so I think that this is probably very compelling evidence for the jury, because we're human and we also tie emotions to content and memories too. This is definitely going to stick out to them.
Great interview. When we come back, Robert Durst is in the hospital. Could the millionaire real estate heir's trial be delayed again? We discuss next. Welcome back. The wife of the infamous drug kingpin Joaquin El Chapo Guzman is pleading guilty to helping run her husband's drug trafficking empire. Emma Cornell Alspiro was arrested earlier this year in a Virginia airport. On Thursday, she admitted in court to 3 charges against her: conspiring to distribute illegal drugs, laundering money, and engaging in foreign narcotics trafficking. She's also accused of helping Guzman escape from a Mexican prison and evade capture. Cornell was born in California and is a dual citizen of the U.S. and Mexico. Guzman is currently in federal custody, serving a life sentence. Testimony in the trial of the millionaire real estate heir is set to resume on Monday after Robert Durst was hospitalized during his trial. Robert Durst is accused of murdering his best friend, Susan Berman, in December 2000 to allegedly stop her from going to authorities about information about his missing wife, Kathy. His defense says the 78-year-old is very sick, suffers from bladder cancer, malnutrition, and chronic kidney disease. But prosecutor John Lewin says Durst has been heard on jail calls saying he would fake dementia and secure a mistrial due to COVID. The judge says Durst wouldn't have been taken to the hospital without a legitimate question to his health.
He was down. He was not in his chair. So he needed to be seen. And is it false? Is it fake? They do a good job at that jail. That's all. I mean, he'll be brought to court if he's good for court in the doctor's opinion at the jail. And he will not be brought to court if he's too ill for court. And I trust that judgment also.
Testimony ended with one of the defendant's friends on the stand as a hostile witness, where he was asked about speaking with Durst in jail. After the jury left, the defense moved for a mistrial.
I didn't really want to talk about what he was here for, and I thought it'd be nice to have discussions about some pleasant things.
Also, his lawyers told you not to talk to Bob about anything related to the case, correct?
Yes, they said that it's not good to talk because everything's
Objections? Yeah.
If Mr. Lewin's purpose is to undermine the credibility of this witness, I think that one could say that he's had plenty of ammunition. To have to comment on Mr. Durst's right to remain silent is more prejudicial than probative.
It is not commenting.
That is a good argument. That's a better argument.
Your Honor, I'm not going to comment at all. This has nothing to do with Mr. Durst's right to remain silent.
He won't stop.
It is not Mr. Durst who's saying things.
Yeah.
It is Mr. Oliver.
Right. So here's the thing. I don't think there's a Sixth Amendment or Fifth Amendment problem here.
Okay.
But I do think this is more prejudicial than probative. So I did strike the answer.
Okay.
I told the jury to disregard it. I'm instructing not to ask questions of that nature. You have destroyed the credibility of this witness already.
Judge Birmingham, help me out here. We've seen a lot of courtroom drama in the Durst case, with the judge letting the lawyers get away with a lot. What do you make of the sparks flying in this trial?
The lawyers and they're fighting amongst each other to devour the entire trial. You want the trial to be about the facts and this well-regulated search for the truth. I mean, and I was commenting, we were talking a little bit over break. This reminds me when the lawyers get too much of the Jack Ruby trial. There's a good book out about that right now called Kennedy's Avenger. But that trial was known more for the sparks that flew among the lawyers than it was for what actually happened in the case. On the other hand, on the other side of the equation, a well-regulated trial might be a good example, might be the Timothy McVeigh trial. All the lawyers talked about how Judge Mage ran a very fair courtroom, ran things, made decisions, made them concisely, and didn't let the lawyers sort of run wild. And you want to be somewhere in between those, I think. That's the goal anyway.
Yeah, running wild is definitely something that seems to be a common thread here in the Robert Durst trial. Terri, talk to us about the prosecution having a hostile witness on the stand, and is it worth having a witness testify when the defendant was literally cheering on his boy Oliver?
Well, Oliver definitely was a hostile witness, and Lewin asked for him to be declared such in the very beginning of his testimony. And that way he could ask leading questions, he could suggest the answer, and I think that worked. But I think Oliver was a bit biased here, and the jury will pick up on that.
Absolutely. Judge Terri, thank you very much, and thank you for joining us here on Law&Crime. We'll see you next time with Justice in America.